everyone, and welcome back to A Little Privacy Please. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Didomi. This week, a Pennsylvania court let a pixel tracking class action move forward under a wiretapping statute we haven't covered before. And the European Data Protection Board weighed in on whether privacy advocacy groups like noyb can be accused of gaming the complaint process. Let's get into it. First, a federal judge in the Western District of Pennsylvania largely denied a hospital's motion to dismiss a class action over its use of the Metapixel and Google Analytics. The case is Brunext v. Warren General Hospital, and the court found that the complaint plausibly alleged that these tools disclosed patients' status, identifying information, and health-related information to Facebook and Google without authorization. The court dismissed the injunction request since the tracking had already been removed and a negligence per se claim without prejudice. Nearly everything else moved forward, including a claim under Pennsylvania's Wiretapping and Electronic Surveillance Control Act, or WESCA. The court held that the plaintiffs had plausibly alleged that the Metapixel was an intercepting device and that the provision principally invoked by the plaintiffs doesn't even require them to plead that the contents of a communication were intercepted. So what does this mean? Well, Pennsylvania is roughly where California was about 2 years ago. WESCA courts are working through first impression questions, while California's SIPA docket has already moved to appellate review, growing judicial skepticism toward expansive SIPA interpretations, and even a proposed legislative fix in the form of SB 690. Although even if that passes, it would only tackle one SIPA provision, the pen register statute, leaving the wiretapping sections in place. Pennsylvania won't necessarily follow in California's footsteps, but we may be able to apply some of our learnings from California to mitigate risk nationwide. So what should companies do with exposure in California, Pennsylvania, and other states with similar wiretapping statutes? A couple of mitigation tactics are worth considering. First, if you decide to get consent, get the timing right. At least in California, the Ninth Circuit has held that Section 631A of SIPA requires consent before interception. A later click can't retroactively authorize earlier tracking. And don't confuse your wiretapping opt-in consent mechanism with opt-out mechanisms under comprehensive privacy laws. The mechanisms serve different statutory duties and can't be thought of as replacements for each other. But at the same time, make sure you're not confusing the user if you offer both. Second, a true server-side setup can change the relevant data flow. It eliminates the direct browser-to-vendor request and may make a contemporaneous third-party interception harder to plead. In one California case, Smith v. Rack Room Shoes, the court dismissed Section 631 claims with respect to server-side tags because the complaint didn't allege how soon the back-end forwarding occurred or whether it was contemporaneous with receipt. Now, the court expressly left open whether server-side tracking enabling contemporaneous eavesdropping can violate SIPA, so it shouldn't be thought of as a legal immunity, but server-side architecture may reduce risk or change the available evidence. Pennsylvania defendants may raise a related argument. WESCA supplements the Federal Wiretap Act, whose electronic interpretation cases distinguish acquisition in transit from later access to stored information. WESCA can be more protective than federal law, though, and no reported Pennsylvania decision has squarely applied Smith's server-side analysis to modern ad tech, but it's definitely an argument to watch. Okay, let's move on to Europe. The European Data Protection Board published a binding decision in a dispute between Belgium's Data Protection Authority and Austria's over a cookie banner complaint filed by noyb. Rather than ruling on whether the banner complied with the GDPR and e-privacy directive, Belgium's draft decision had tried to dismiss it outright as an abuse of rights, citing noyb's standardized, partly automated complaint process and a complainant whom the Belgian authority viewed as outside the site's ordinary audience. The EDPB disagreed. Abuse of rights requires an objective element, whether the process was artificial or contrary to the rule's purpose, and a subjective one, whether the real intent was something other than protecting the individual's rights. The board agreed noyb played a leading role and used automated tools, but because the individual had validly granted noyb a mandate under Article 80 of the GDPR, letting someone authorize an organization to complain on their behalf, and the Belgium draft didn't establish that the mandate was invalid, the objective element wasn't satisfied. On the subjective side, the board found no evidence noyb was pursuing anything beyond the individual's interest, or that the complainant received any benefit, and ordered Belgium to decide the complaint on the merits. The takeaway: this sets a high bar for dismissing an NGO-backed complaint just because it's organized or automated, but it doesn't kill the abuse of rights defense, since the EDPB was explicit that the ruling is case-specific and doesn't prejudice others. Once the complaint reaches the merits, the questions will be familiar. Are non-essential cookies or trackers held back until consent? Are boxes pre-ticked? Are purposes clearly explained? And is there a clear, accessible way to refuse? Per its 2023 Cookie Banner Task Force report, a vast majority of participating authorities said a banner with an accept button, but no refuse, reject, or not consent option on any layer doesn't produce valid consent. There's a strong supervisory consensus there, though it's not itself a binding EU-wide rule. So we have two different stories with one shared thread. In the US, plaintiffs keep testing website tracking under state wiretapping statutes, and developing case law brings both opportunities and significant threshold defenses. In Europe, the EDPB made clear that a complaint can't be dismissed as abusive merely because it's an advocacy group organized or automated the process. For companies using pixel or similar tracking on consumer-facing sites, revisit consent timing, the data actually transmitted, and whether server-side architecture changes the relevant flow and evidence. For those relying on European cookie banners, assume an NGO-backed or standardized complaint won't be dismissed on that basis alone. The authority may still have to confront the banner's substance. That's it for this week. You can find more detail in the newsletter, also called A Little Privacy Please. I'm Julie Rubash. Thanks for joining me, and I'll see you next week. Until then, go enjoy a little privacy, please.